Good morning, everyone, and welcome to today's webinar, IP Protection for Innovative Tech Companies. My name is Alessandra Capriglia, and I am Project Manager of the China IP SME Helpdesk, which in a nutshell is a EU-funded initiative providing free initial advice to small, medium enterprises that are interested in trading with China or are already present in the Chinese market. And we cover both protection and enforcement of intellectual property in China in 4 jurisdictions. So we cover mainland, Hong Kong, Macau, and Taiwan, each of them having their own IP system. Over the last 15 years, we have assisted hundreds of thousands of SMEs from Europe and from the COSME and now from the Single Market Program. Of course, our most important service is our helpline address. Please do feel free to note down this address and be in touch with us with any question you may have or concerns about your IP strategy. We have a team based in Beijing, a team based in Europe. You can contact us via email or via phone if you're already in China. We respond with a free and confidential first-line advice within 3 working days. We organize trainings and workshops and webinars such as this one with focus on different IP rights and also more vertically on different sectors. We can organize one-on-one sessions with our in-house IP business advisor. So you can contact us and reserve a slot to talk about your IP strategy or IP concern. And of course, again, it's free of charge. On the website, you'll find a variety of materials such as IP guides, goods on sectors or different IP rights, fact sheets regarding each Chinese jurisdiction, real-life case studies, infographics, and so on and so forth. You can also find our blog where we upload articles written by our network of over 40 IP lawyers that we have in Europe and in China. These are examples of materials that we have. As you can see, we have here an IP fact sheet on mainland China, or on the right-hand side, we have an IP guide on technology transfer to China, which might be actually very interesting for you. The China IP SME Helpdesk is part of the big family of the International IP SME Helpdesks, all EU-funded projects. So in case you are also interested in other regions around the world, such as Africa, Southeast Asia, India, Latin America, or within the European region itself, feel free to visit the website where you can find all the contact details and all the materials that you can download free of charge. On social media, we promote our upcoming activities, our latest publications. We upload recording of webinars on our YouTube channel, so if you missed something, you can still rewatch it. If you're already in China, you're familiar with Chinese social media, for sure you have already WeChat. Feel free to scan the QR code and follow us also on WeChat. Once again, feel free to contact us at any time with your IP questions. We'll be very happy to support you. Now I give the floor to Gwenn Sonck, with whom I'm organizing this event today. And thanks a lot, Gwenn, for, again, always working with us. The Flanders-China Chamber of Commerce is one of our closest partners, and I'm very happy to start this new year with this new event with the Flanders-China Chamber of Commerce. Gwenn, I'll give the floor to you for a moment.
Thank you very much, Alessandra. So, ladies and gentlemen, good morning. Also on behalf of the Flanders-China Chamber of Commerce and the EU-China Business Association, warmly welcome you to our joint 10th webinar with the China IP SME Helpdesk. it's very important that companies doing business with China also have an IP strategy included in their China business plan. China is changing, as you know, and doing business has become more complex in a slowing market, and with local competitors scaling and with geopolitization running hot, it's a very challenging business environment. This confluence of developments demands European companies to rethink China and recalibrate appropriately for a possibly different business environment. But despite this, many of our companies view it as imperative to maintain a footprint in China because of its market size, dynamism, and industrial clusters, which are not replicated anywhere else in the world. In 2022, Europe invested $12.1 billion in China, which is an increase of 70% compared to the previous years, with the automotive industry continuing to be the largest hotspot, and Chinese investment in the EU increased by 21% to $11.1 billion during the same period. And battery investments are now the mainstay of Chinese FDI in Europe. The EU and China have a daily trade volume exceeding 2 billion euros, making the two sides each other's second biggest trading partner. According to a recent survey of European companies in China, the top 3 challenges for European companies based in China are: first, the slowing down of the Chinese economy; secondly, the global economic slowdown; and thirdly, the geopolitical situation. The attractiveness of China as an investment destination varies by sector, and 60% of European companies surveyed that China is currently a top 3 destination for investment, and 55% reported the country as a top 3 investment destination for future investments. Many of our companies are in China for China, as I said, for the size of the market, the local supply chain, and very importantly, for its innovation power. Innovation is also one of the reasons why European companies want to be in China. European companies say it is crucial to do the innovation where the applications are. And for our companies that's in China, they cannot allow not to be close to their customer, and because of that, delay the introduction of new innovative products. So if our companies want to keep up with the technology of the future, then they must continue to invest in China. The speed of innovation in China is very fast and keeps our companies sharp. China is lodging more than 60% of AI patents with the World Patent Organization. Talking about the speed of innovation, China's ranking in the Global Innovation Index was 34th in 2012 and 11th in 2022. So being in China shouldn't really be a choice. You must take advantage of the innovation and the local market. Let me now say a few words about the role of the Flanders-China Chamber of Commerce. Our chamber is founded by the largest investors from Belgium and China, such as Bekaert, Umicore, Barco, Ageas, Agfa, KBC Bank, Picanol, and so on. Our aim is to assist Belgian companies to enter the Chinese market and to assist Chinese companies to invest in Belgium and Europe. Our activities are executed in cooperation with our structural partner, Flanders Investment and Trade. Our aim is to provide information, exchange of experiences, and share our network in China and the EU. We provide a weekly China business newsletter to keep you up to date on China's economy and foreign trade. We organize webinars and conferences on how to and how not to do business with China, and give expert advice and receive Chinese delegations again and introduce them to our member companies. We are also in charge of the EU-China Business Association, which is the association of bilateral China business associations promoting the economic and trade relations between China and the EU. Today, we have 20 member associations and represent more than 25,000 European and Chinese companies. The EU-CBA which is the EU-China Business Association, is also an official associated partner of the EU SME Center. The EU SME Center is the European Union initiative that provides a comprehensive range of hands-on support services to European SMEs, getting them ready to do business in China. Their team of experts provides advice and support in 4 areas: business development, law, standards and conformity, and human resources. From first-line advice to in-depth technical solutions, they offer services through knowledge, advice, training, and advocacy. And we also keep you informed about those activities. And as mentioned, we are also a very good partner of the China IP SME Helpdesk. I would like to end here and give the floor back to Alessandra. Thank you very much.
Thanks a lot, Gwen. Now, if you allow me to do a little exercise with you before giving the floor to our IP expert, I would ask you to run with me a little quiz and assess how much you know about your IP in China. This will allow our expert, Valentin, to define the level of depth of information that he will need to cover during the presentation. Also, as you know, the China IP SME Helpdesk is an EU initiative free of charge, so it is important to regularly assess the impact of our activities. So I'm going to share with you now the quiz, and I would ask you to take your phone, take your device, and go to menti.com and insert the code that you see on the screen, and either to click on the link that I shared on the chat. And I will wait for a few seconds until some people will join. There will be just 3 questions about 3 different IP rights. And we'll see then also at the end of the training if you change your mind after what Valentin is going to share with us. I want to clarify that all responses are anonymous. So no personal data is stored, which means that we will not see your name behind your answers. All right. So I see that some people started to respond. The first question is, Chinese utility models, which statement is true? Utility model can protect an innovative process. It can be registered together with innovation patent. The application time is much longer in comparison to invention patent. I see that the second one is the most successful. Still wait a few seconds. All right. Now, passing on the next question. Oh, I see that people are very active. Thanks a lot for that. Passing on the next question. Trade secrets. Today we're going to talk about trade secrets. Which statement is true? Trade secrets is about protecting information only via contracts, such as NDAs. Risks come mainly from business partners. They can protect algorithms. All right. All right. Now passing on the last question about copyright. Which original work can be protected by copyright? Company manuals, logos, software, or all of them? All right. Well, thanks a lot for your very active participation in this little exercise that we started doing to assess the impact of our activities. Now I will give the floor to Valentin, who is our one of our key IP experts of the China IP SME Helpdesk. Thanks a lot, Valentin, for running the training for us today. I look forward to listening to your training. Please do feel free to use the Q&A session to ask any question you may have about any content that Valentin is going to share. Thanks a lot and enjoy the session. To you, Valentin.
Thank you, Alessandra. Can you hear me?
Yes. All clear.
Perfect. Well, thank you, Alessandra. Thank you, Gwenn. Hello, everyone. Very happy to be here today in my capacity of expert of the China IP SME Helpdesk. A few words on myself. Well, I'm an IP lawyer. I've been active in the field for close to 20 years now. I used to live and work in China from 2012 to 2016, 4 years during which I mainly worked for a Chinese IP boutique firm based in Shanghai, where I was mainly supporting a European client base with all their IP issues when dealing with China. Today, I work at Osborne Clarke. Osborne Clarke is originally a British firm. It has evolved into an international legal practice. We are very much present in Europe, but we are also present in Asia, and we do have an office in Shanghai with whom I have the pleasure to work on a regular basis. And so we basically support our clients when dealing with China, including in terms of IP, which is the core of my practice. I mainly work in the patent, trade secrets, and open innovation fields. And obviously also I deal with China. Previously, I was doing really everything that was related to China and IP. Today, I mainly work on contracts and complex tech transfer agreements with China. The topic of today, IP considerations for innovative tech companies. So I will talk about, well, obviously IP in China with this angle. This question, China is aiming at becoming more self-reliant in science and technology. From an IP perspective, more challenges may occur for innovative SMEs. It's obviously a good question. It's a complex question. And to tackle this, well, I have divided my presentation in 3 parts. We'll start with some words on the context of IP in China. It will be quite a lengthy introduction. I think it's interesting and important to understand, well, how the Chinese IP system has evolved over the last years and where it is heading to. I will then focus on how to protect your IP in China. Actually, very high level, very basic and introductory advice. So that's, well, the less seasoned IP people in the room can understand and follow. If you have more complex questions, well, I will be happy to follow up after the webinar. You have my email address and the slides will be shared. And I will then finish with one single slide with key takeaways, the lessons learned that I hope you will take away with you after this webinar. So let's start with IP in China and some words on the context. I think the first thing that is important when you look at IP in China is the very, very strong evolution of the IP system in China. It's very impressive and interesting to see how it has evolved over the last decades. At the end of the 70s, when the country opens up to the outside world, well, basically you had no IP laws in China. Fast forward 40 years, 2023, well, IP has become a top national priority. You all know that innovation is absolutely key for China today. Gwenn has mentioned it. China has become a very strong innovator. And well, when you talk about innovation and when you focus on innovation, you have to focus on IP because IP has been put in place to enable businesses and actors to protect, to appropriate, to monetize the result of their innovation. So China today is part of the World IP Order, a member of the World Intellectual Property Organization. It's part of all the main international treaties and agreements. And as a result of this, well, you have a complete set of Chinese IP laws that are in place. And what is very interesting and impressive is the legislative dynamism. So all these laws are constantly being adapted. Between 2017 and 2021, all the main IP laws were amended. The fourth amendment of the Chinese patent law entered into effect in June 1st, 2021. And nowadays, well, the trademark law is once again under revision. And so it really illustrates a very strong focus from the Chinese authorities to adapt constantly the IP laws to have, well, basically the best system in place to suit the interests of the Chinese economy and of the Chinese companies. So China is the #1 country for patent applications. As you know, China is a country of numbers. But what is interesting here is that in 2015, well, more than 1 million China invention patent applications were filed with the Chinese Patent Office. First time that such a large number, more than 1 million, were filed with a single patent office. So China made the headlines. It raised the question, well, what does this mean? Has China become a true innovator, or is this mainly the result of targets that are imposed on Chinese businesses? Reality lies somewhere in the middle, but what is clear nowadays is that indeed China has become a very strong innovator, and that slowly China is really moving from numbers and quantity of patents to high quality patents. And this is an important aspect. I will come back to this. 2021 latest numbers, more than 1.5 million Chinese invention patent applications filed. What is interesting here is that most of the patents are domestic. So 90% of the patents, invention patents filed in China, originated from companies that are based in China. Only 10% were the result of foreign applicants. Internationalization, important to know, and you may have noticed that already in your business and in your activity, is that China is strongly internationalizing, and that Chinese businesses are developing sophisticated and valuable IP portfolios abroad. One illustration of this is that China was once again in 2021 the #1 PCT applicant. What is the PCT? It's the Patent Cooperation Treaty. It's basically an international treaty that enables businesses to internationally file patent applications. And the biggest PCT applicants was China. China was also the country with the most applicants to feature in the top 50 university lists. A Chinese entity, the Shenzhen Institute of Advanced Technology, became the top PCT applicants in the government sector. So it really illustrates that businesses, universities, governments are all massively using the Chinese IP system, but also internationalizing and building valuable patent portfolios abroad. Also worth mentioning that in 2021, that same year, well, Huawei was the top PCT applicants, the single business worldwide to file the most PCT applications. Important to know, and this can have a very direct consequences for you if you're active or want to become active in China, is that China is the most IP litigious country in the world. In 2021, more than 30,000 patent litigation cases were introduced in first instance. It's an absolutely huge number. If you compare to Belgium, I don't have the numbers, but I suspect it must be between 20 and 30. So 1,000 more patent cases were introduced in China in 2021. What does this mean? It's not just only a number. It means that you have highly specialized patent judges. You do have specialized IP courts now in China that deal with complex technology-related cases. And so you do have judges that are highly experienced, that were involved in hundreds of patent cases, and so that perfectly understands what a patent is, how the patent system works, what the value of a patent is, and that render basically very qualitative patent court decisions. Again, here, Worth mentioning is that IP litigations are mostly domestic, so they oppose Chinese companies between themselves. Latest number I saw that was that 99% of the cases were opposing Chinese companies that have developed valuable patent portfolio and that are using these patents in the economic war that they are waging between themselves. Interesting also that if you look at the published cases, you have a higher win rates of foreigners. Now, all the cases are not public, so you obviously have a selection here that enables to say that the foreigners win more than the Chinese, which is maybe not true, but what is certainly true and interesting and important to mention is that as a foreign company, you can win your patent cases, you can win your IP cases in China if you do your job, if you have the relevant IP rights, if you work with the relevant expert lawyers, and that you use all the enforcement tools that the Chinese IP laws are offering, well, you can obtain very good results. An important trend that has been noticed these last years is that you do have an increase of cases that involve foreign businesses, and you have more and more cases that are filed against foreign businesses for IP infringements. And I'm citing here an article from the Financial Times of September 2021. Foreign businesses in China are becoming key targets in a growing number of IP lawsuits filed by Chinese companies. And it's very important to be aware of this because it means that you really need to have an IP strategy when you do business in China. You really need to understand how IP litigation works, where the risks are, and you need to tackle them in advance because the chance is real that, as in any other market, but maybe even more nowadays in China, well, you may be attacked for IP infringements when doing business in China. And this will be particularly true and relevant in strategic technology sectors that are promoted by the business governments. You may be active in these sectors. Usually being active in these sectors opens up opportunities on the Chinese markets, but the downside of that is that you have more sophisticated IP portfolio and more aggressive Chinese competitors on the market, and so you are more likely to be the target of an IP litigation. You also have more cases, IP and patent cases, especially that oppose foreign businesses between themselves in China, because China is a very strategic jurisdiction where to litigate patents, because you can block, for example, a competitor for commercializing a product or a specific technology on the Chinese market can have a significant impact. Also, another reason is that China remains an important manufacturing base, and so if you can obtain an injunction against a competitor blocking him to manufacture a specific component on the Chinese in China, well, you can disrupt his global supply chain, and this can have a very significant effect. So litigation in China, it's important to be aware that as a foreign business doing business there, you may be involved in litigation, not necessarily as plaintiff, but as defendants attacked by Chinese or by foreign competitors active on the Chinese markets. What is the state of innovation? Well, Gwenn pointed out the fact that China had become a very important innovation center. If you look at the numbers of R&D spending in China, well, they grew tenfold between 2000 and 2016. It's expected that China will pass US on R&D development spending by 2025, which means very soon. And I think it's today everyone is aware of the fact that China has become a strong innovation center, but that is fairly recent. When I moved to China in 2012 as an IP lawyer, well, people were frankly laughing at me. Oh, you're going to China, Chinese copycat country, they can only copy, etc., etc. This was a total misconception of what was going on in China at the time. China was very busy and focused on developing its innovation capacities. And look, today, nobody challenges the fact that China is a very strong innovator and that in certain emerging tech, in the tech sectors and technologies, well, they have surpassed the US and they are clearly have become global leaders. And so this raises two questions, I think important and relevant to you, is whether China is out-innovating us, out-innovating European companies. And the answer is clearly yes in some sectors. And what impact does this have on IP and on the IP strategy you should put in place if you're active on the Chinese markets? Now, important to realize that IP has become a political imperative. There is this very clear goal already for many years that have been announced, this goal to become a self-reliant technological powerhouse. China wants to end its reliance on foreign technology for very good reasons. One of them already mentioned and referred to by Gwenn, geopolitical reasons. And I'm citing here a headline of an article published a few days ago. Dutch group chip equipment export amid US pressure. You probably have read about ASML and the fact that they won't be exporting semiconductors manufacturing technologies to China under pressure of the US. The US is trying to slow down the capacity of China to innovate in certain strategic industries. And that's obviously negative for the country. And it explains, it's an illustration of why it's so important for China to become self-reliant technologically. And so, well, this ambition and this goal is very clear in several five-year plans, including the latest, the 14th five-year plan that covers 2021-2025 periods, where this is a clear aim, a clear goal that is announced. Now, if you focus on innovation, as I mentioned already, inevitably you will focus on IP, because IP is there to enable businesses to protect the results of their innovation. And Chinese authorities are very well aware of this, and they are strongly supporting the development of an efficient IP system at the highest level of government, including President Xi Jinping himself, citing here a speech that he gave already 4 years ago. Without innovation, there will be no progress. Full IP protection will not only ensure the lawful rights and interests of Chinese and foreign companies, it is also crucial to promoting China's innovation-driven and quality development. And it's very important. China is a clear driver of innovation, but this drive of innovation is also supported by other, maybe even more important components, which are, well, a centralized planning. China is not a free market economy as we know it. There's a lot of planning, including in R&D, including in innovation, and combined with a strong focus on IP, well, this is a very strong driver that gives a strong advantage to your Chinese competitors. So is China out-innovating us? Very briefly, well, China is very sophisticated and focused. As I just mentioned, they're really planning to become leaders in certain tech sectors. If you look at certain indicators of the innovative output of a country, well, you can see that China is leading. Patents in certain tech sectors, deep learning, for example, you have way more Chinese applicants than US applicants, for example. If you look at peer-reviewed scientific publication, China authors outnumber the US authors. Education, more Chinese engineering graduates than in the US. So very clear and significant indications that China has become a very strong and fierce innovator and competitor. Now, obviously, what is the impact of this on IP? That is an important question. What is the state of the Chinese IP system? Well, I mentioned already great improvements. China has focused on developing an efficient Chinese IP system, and the system has improved. So nowadays, Chinese companies have developed valuable IP portfolio, not only in China, but also abroad. And as I mentioned already, but very important to realize this, China is really now focusing on quality patents. They have been focusing on quantity, but that was years ago. Now it's really quality that is the key priority. And so really the system is maturing. They are moving from big numbers to a real innovation, real growth backed up by quality IP rights that enable them to innovate not only at home, but also overseas, including in Europe. So what impact does this have on SMEs, this goal of technological self-reliance. What are the related risks? Well, the biggest risk for your business may be IP theft and IP leaks. That remains an important problem, and you do need to have a strong strategy to tackle this when you do business in China. But it may be that tech competitiveness is the biggest risk to your business, and I think it's very important to be aware of this. Here, a short example of this, we were consulted a few months back for technology transfer between China and Europe for innovative battery technology. What was interesting here is I'm used to handle tech transfer from Europe to China, and here it was the opposite. We had a Chinese business that was planning to set up a company in the EU to commercialize a new generation of batteries, specific technology in the EMEA region. And so the technology had been developed by a Chinese company in China. It was owned by a Chinese company, and they had developed a very relevant patent, but not only patent, also trade secret portfolio in China and abroad. And so the Chinese company was really using IP as a tool to succeed, not only in hope, but also to internationalize. And so the plan here was to set up a Belgian company, a joint venture between a Belgian company and a Chinese company that was the owner of that technology that had to be licensed to the new Belgian company. And obviously, well, central to this deal was a complex tech transfer agreement. And this deal was only possible because the Chinese company was very much IP aware, very much IP focused, and they had the relevant IP portfolio to be licensed to Europe. Now, so interesting illustration of what I have been explaining. Now, what can we learn from these facts and figures? Well, obviously, you will have understood it by now. The Chinese IP landscape has changed. It has improved very strongly. It's possible to protect and to enforce your IP rights in China. IP system is massively used by Chinese companies. It's available to foreign companies. You need to understand to use it if you want to be successful in China. IP has become essential for Chinese businesses. The China stake in the IP system has grown and is very significant. And again, as a result, your Chinese competitors are IP-focused competitors. And then, well, this broad aim, this goal to end technology dependence and to be self-reliant technologically has concrete consequences for European SMEs. And I think that there are two main consequences. The first one is that it opens up opportunities in the short and medium term for European tech companies that are active in the strategic industries, that are promoted centrally by the Chinese authorities. Well, plenty of opportunities. Funding may be available, and so you can use also your IP to attract Chinese investments. And we've been active in an interesting case last year where an EU company transferred technology through China and attracted at the same time investments from the Chinese partner in the Belgian company. And IP was absolutely central to attract this Chinese investment and to develop the market access to China. It opens up opportunities for tech transfer, as I just mentioned, contract manufacturing, R&D for Chinese firms, supply of critical technologies to Chinese firms, provide support in internationalization. But again, and that's my key message, all these opportunities that are there, they will only be open for Belgian companies or European companies with a strong IP strategy that is tailor-made to the Chinese context and to the Chinese needs. So that's a first thing, opportunities very clearly. In terms of IP, what is the impact? Well, I think two angles: the domestic impact, what is the impact for your activity of doing business and developing an IP strategy and IP portfolio in China? Well, in China, you will be faced with increased filings in strategic industries. So more and more, for example, patents that are filed. And so this will render the development of your IP portfolio in China more difficult. You may face greater scrutiny of foreign IP filings in strategic industries, so more difficult to acquire rights. And you will also face more foreign IP invalidations. So if you develop and you obtain patents in China, the risk is higher in strategic industries to have a Chinese competitor that will attack the validity of your patents when doing of your Chinese patents. It's so important to be aware of this and to integrate this in your patent portfolio development strategy. And also more IP disputes, as I mentioned, more Chinese IP assertiveness, more patents, more IP portfolio owned by your Chinese competitors that may invoke them against you when developing on the Chinese markets. The impact of IP has also, well, a global effect, because Chinese companies will basically develop valuable IP portfolio abroad. So more outbound IP filings in strategic industries, including trademarks, patents, and designs as well. So let's focus now on a few tips on how to protect your IP when doing business in China. I think first step, and it's very basic, but it's very important, is that you should know your IP and you need to be aware of what you need to protect. Intangible assets are non-physical, so they may be difficult to identify. And what I see in my practice, it's that very often SMEs, younger companies, less sophisticated companies, well, they do not have an overview of their IP assets. And so they basically do not know what they have and what they should protect. And so the first step, if you want to develop a China-focused IP strategy, is to conduct an IP audit and to understand, well, what in your products, what in your technologies, what in your branding strategy is protected. Recent example, 3 weeks ago, I was consulted by a Belgian medtech company. They consulted me to renegotiate an OEM agreement with their Chinese partner. Chinese partner is their single manufacturer and supplier of all their products, and started discussing of the contract, the terms, what they wanted to renegotiate. And I realized that they had no single IP right registered in China, not even a single trademark. This is crazy. But today in 2023, companies that are heavily relying on China, for example, for their manufacturing of key products or key technological components, well, some of these companies do not have an IP portfolio in China. And so it's a reality for less sophisticated and for SMEs, not at all to have an IP, a China IP portfolio. And so the first thing to do, identify your IP, understand where you are protected. Once the IP is done, step 2, well, you need to understand what you have to protect, and you need to understand what is basically missing in your IP portfolio. So step 3, you need to understand what you have to protect, but also how to protect it. And here, well, you may know this, but you have basically 2 ways to protect the results of your innovation. You have on the one hand IP rights, and on the other hand trade secrets. Different types of rights. An IP right is an exclusive right, so it grants you a monopoly, only you. Well, basically it means that you can exclude others and forbid others from exploiting the object of your right. So if you have a patented invention, you can exclude your competitors from exploiting your invention without your authorization. And in the tech sectors, well, the main IP rights that are relevant will be patents and copyrights. Second type of rights, trade secrets, there are no IP rights, so you don't have a monopoly on the information that is protected as a trade secrets. Trade secret protection is based on the nature of the information. It must be secret. It must have commercial value because it's secrets. And the protection will be based on the way that the information is handled by the business. Basically, what does this mean? It means that you need to proactively protect the secrecy of the information that you want to see protected as a trade secret. And so the trade secret doesn't grant you a monopoly, it protects you against unlawful acts, against unlawful access, disclosure, use. Typical example, an employee is leaving your company. He copies your source code and sets up a competing business. Well, if you protected your source code as a trade secret, you took the relevant measures to protect it, well, you will benefit from the trade secret regime and you will be able to act against that ex-employee that unlawfully accessed, copied, and used your trade secrets. And very often in the tech sector, well, trade secrets play an important role and protect the crown jewels of many tech companies. Step 4, very important, create a bundle of rights. Again, basic advance, but very important, especially for younger SMEs and less IP-focused SMEs. Understand that each type of IP rights has a specific function. Trademarks will protect your brand identity. Patents will protect technical features of your products and processes, including all computer-implemented inventions. Designs will protect the external aspects of products, including, well, graphical symbols and a graphical user interface, for example. Copyrights will protect creative works. A very broad variety of works are protected, including computer programs, databases, technical drawings, and basically logos as well, as was asked in the quiz. And then trade secrets, again, they protect a very broad series of confidential information, not only technical information, but also commercial, financial, strategic information. And trade secrets are used in the tech sector, among others, to protect data and data sets, to protect algorithms, and to protect source code as well. So understand that, well, the same object can protect different types of IP rights. I always use this very simple image of a biscuit packaging. Well, plenty of IP rights that could be invoked, and that could be the object of your IP strategy. Obviously, I would never recommend the clients to go for all these types of protection, but the message here is understand that your technology may be protected in several ways through different IP rights, and it's important to create a bundle of rights, to layer your IP, because the more IP rights you will have, well, the better equipped you will be to tackle IP challenges on the Chinese market. Step 5, well, very important to have enforceable IP rights, and this requires to have a strategy and to be proactive. Again, very basic information, but crucial. IPR are territorial rights. So it means that if you have a Benelux trademark, well, you're not protected in China. It's the basics, but it's important. Coming back to this medtech company that consulted me 3 weeks ago, they had a single Benelux trademark. And well, it's very good to be protected in the Benelux, but it was not of a lot of use for create leverage and protect their brand identity when negotiating their OEM agreements with a Chinese partner. So important to have a global strategy to cover all the countries where you trade, you manufacture, you exhibit, where your competitors are located, where possible investors are located, and very much for all these different criteria, as I would say, well, China will be an important country. Remember also that registration is needed. IP protection, with the exception of copyrights, is not automatic. So you need to proactively ask to be protected. You need to apply for protection, and you need to do that on time. So you need to anticipate, you need to plan early, you need to work with professionals to do that. And I always use this important example that not applying in China for protection, well, it's the same as granting a free license to use your inventions in China. If you don't apply for patent protection in China, but you do in other countries, your patents and the content of your invention will be public, but you will not be protected in China. Your invention will be in the public domain, which means that anyone can freely and can legally use your invention on the Chinese market, which is something that you may want to avoid. Very important, obviously, to have enforceable IP rights to adapt to the specificities of the Chinese IP system. And so we'll basically message here, work with people who are experienced and understand how the Chinese IP system works. Step 6, extremely important. Again, basic, but very, very, very important. Pay attention to IP in your contracts. Contracts are absolutely key to successfully protect your IP in China. Pay a lot of attention to IP and confidentiality clauses. Understand how it works in terms of ownership, who owns the amendments, the improvements of your technology. You want to develop and localize your software. You hire a third party to work on this. Who will own the copyrights on the code that has been developed in China? Critical issue. You have to tackle this by contract to avoid bad surprises and realize that eventually, well, you don't own what you have paid for and what you have developed. It's owned by your Chinese partner that licenses it to you, and that can have a lot of leverage on you when you're active on the Chinese market. So, and even abroad. So very important. Take the time, dedicate the relevant resources, human, time, and financial resources to negotiate your contracts in great detail, and understand that loads of contracts are concerned by IP, not only tech contracts, but also obviously trademark and copyright licensing, manufacturing agreements like OEM agreements, distribution and sales contracts, and very important, employment and consultancy agreements. You need to tackle your IP and your trade secret protection, so the confidentiality clauses in all your agreements with your employees and third-party people with whom you work. Now, very briefly, I only have 3 minutes left. Patents, copyrights, trade secrets. Well, Chinese patents in a nutshell. What is very interesting in China is that you have 2 types of patents. Invention patents, they're basically the same as what we have in Belgium and in Europe, but you also have utility models. And they are a small small type of patents that only covers products, not processes. That's important to understand. The patent rights granted are also more limited. They're valid for 20 years from the date of filing for invention patent, only for 10 years for Chinese utility models. And in terms of patentability requirements, well, more or less the same as here: novelty, inventiveness, and practical use. And so if your patent is granted, well, then you have a monopoly right to exclude others from using your invention on the Chinese market without your authorization. Important to understand is that it's nowadays more easily to patent computer implemented inventions in China. The patent examination guidelines were amended in 2020 in this regard. So we now have clear guidance on the examination and drafting requirements for computer implemented inventions, which may be very relevant for companies which are active in the tech sector. Chinese utility model, as I said, it's an interesting feature of the Chinese patent system. And what is interesting to see is that, well, basically, invention patent utility models are underused by foreign companies. If you look at the ratio of invention patents owned by foreign and Chinese companies, ratio is 1:9. You look at utility models, the ratio is 1:382. That's a big difference. So it means that utility models are totally underused by foreign businesses. And what is interesting with utility models is that it's easy to obtain, it's very cheap, it's very quick to obtain Chinese utility models. And so you should really take advantage of these valuable IP rights when doing business in China, because it will grant you the same rights as for an invention patent. And don't have the time to elaborate, but you can file at the same time an invention patent and a utility model. Utility model, you get quick protection. And once your invention patent is granted, you abandon the utility model and you have your invention patents that will likely be stronger and with a longer protection of 20 years. Second, very important to protect trade secrets. What can be protected? Well, I referred already to it, a very broad range of information, including algorithms, data, computer programs, software codes. The requirements are secrecy, commercial value because it's secret, and reasonable steps. So you need to proactively protect the secrecy of the information to benefit from the trade secret protection regime. And know that the main body of law to protect trade secrets, the entire and fair competition law, was amended twice in 2017 and 19, basically to strengthen the trade secret protection regime, which remains challenging. And it's important to be aware of that. what reasonable steps. You will have the slides. I'm referring to useful guidance on what types of measures you should implement to protect your trade secrets in China. So here again, very important to be proactive, to have a strategy, to audit and improve the protection measures that are in place, and keep in mind that having an NDA is a must. It's a good start, but it's not enough. But what is very important is to adopt other measures, and above all, to document all the transfer of the confidential information, because it's all well and good to have an NDA, but if you cannot prove that specific information was communicated under the SDA to the other party, well, you will not be able to evidence the access to your trade secrets, and you will not be able to enforce your trade secret rights. So very important to document everything, the measures you take and the information you communicate or to which your Chinese partners or employees have access to. Almost the last slide, Chinese copyright protection in a nutshell. Well, basically, you answered the quiz pretty well. Copyright protects original works, no abstract idea or concept, but a work is a very broad notion. It's the main right which is used to protect software as such. It protects source codes and proprietary materials. It also protects manuals, website contents, marketing materials, logos, etc. Copyright protection is automatic. What is interesting is that in China, they have put in place a voluntary recordation mechanism. So you can record your copyrights, obtain a certificate that will say that you are the owner of these copyrights. Can be challenged, but it's an important certificate that very often will be required if you want to enforce your copyrights in China. It's also very useful if you want to negotiate and license some copyrights to have it recorded. And it's also possible to do it for software, obviously with confidentiality measures, so that you don't have to disclose the whole of your source codes. So that leads me to my last slides. Again, basic but important advice. Very important to align your IP strategy to your China and your global business needs. Remember 5 things. First of all, the Chinese IP landscape is constantly on the move, and it's changing and evolving to support the competitiveness of Chinese companies. Second, the main IP issues that foreign companies face is very often because they did not have a relevant strategy and they failed to take the required steps. And if you don't do that, you will run into the problem that is 100% guaranteed. 3, plenty of opportunities still for European SMEs, especially those active in strategic sectors that are promoted by the Chinese governments. But you will succeed only if you have a strong IP portfolio that will protect your strategic and competitive advantage on the Chinese markets. So to be protected, be proactive, have a tailor-made IP China strategy. So start early, have a strategy, know your IP and perform an audit, register, build a relevant IP right portfolio and layer your IP rights, adapt to the local specificities, focus on your trade secrets, negotiate your contracts in great detail, make strong due diligence on your partners, very important aspect, and raise awareness of the importance of IP with your management. And then last but not least, well, be confidentiality obsessed, focus on human resources, and document basically everything in terms of secrecy, the measures you take, and the confidential information that you share with others. That's it. Any questions we won't have the time to discuss. Was a bit longer than expected, but don't hesitate to drop me an email and I will be happy to discuss and to help if I can. Thank you.
Valentin, thanks a lot for this very comprehensive presentation. I think it would be good to go through, give the audience a couple of minutes to write down their questions. I think, yeah, even if we're a little bit late, maybe we can focus on the key elements of the IP strategy that you covered throughout your presentation. And I would ask again the audience to maybe open the quiz and see if this time maybe everybody will get the right answers, and if there is still some wrong answer, maybe we can go a little bit more in depth about this specific aspect. Once again, you can go to menti.com, enter the code, or click on the link that this time hopefully you will see. Apologies for earlier, I think I sent it just to one person as a private message. Now you should see it on the chat. So regarding utility model, you mentioned very briefly that it can be registered together with invention patent. And I see that, yes, everybody is getting now the right answer. And can you maybe develop this thought a little bit more? Because I know it's a very underrated, underestimated aspect of IP strategy for tech companies.
Yeah, well, so first thing to say is that utility models may be more difficult to obtain for digital technologies, but certainly if you're active in IoT and you have specific pieces, technology, hardware-related technologies, utility models can play a role. As I said, if you look at the numbers, not many foreign businesses are using utility models, while they are cheaper to obtain. Why? Because the Chinese Patent Office will not make a substantive examination of the utility model, so they will not check if the utility model meets the patentability requirements, novelty, and investing step mainly. So it's easy to obtain it. The right is a bit less strong because it wasn't examined substantively by the Chinese Patent Office, but it is quickly granted, and then it grants you the same rights as an invention patent. And indeed, you have this possibility to jointly file at the same time utility models and invention patents, provided obviously that the invention at stake can be protected by a utility model. And so, yes, the strategy is you get quickly your utility model in 6 to 8 months. You have your utility model, you can enforce your rights. In parallel, your invention patents go through the whole application and granting process. It's examined in depth by the Chinese Patent Office, and it decides to grant the invention patents. Well, then you abandon the utility model. What is also an interesting feature of the utility model is that the inventiveness requirement and threshold is lower than for invention patents, which means that an invention that would not meet the inventiveness requirements of an invention patent, well, basically you cannot obtain an invention patent for that invention, but you could still have a valid utility model with the same rights attached, but for a shorter term.
Yeah, and I think this actually answers those two questions that we received through the chat. If utility model is fast, can it happen that it gets granted and the patent is not? So if the utility model, does it mean that it's not necessarily, the patent is not necessarily granted just because the utility model is granted, right? There are two different filing processes.
Is the place where the invention took place important? Is this decision? I would say no. You do have requirements, among others. If you perform R&D in China, you have to first file in China. So this is very much regulated. Important to be aware. Otherwise, you can lose your patent rights in China. If you use the PCT and you enter into national phase, you have to choose between invention and utility models. So choices are to be made. Among them, well, obviously, is it patentable through a utility model? But you have several factors that can be taken into account. One can be the duration of the relevance of the invention that is protected. If the product or technological life cycle is very short, well, maybe 10 years is sufficient. You don't have to, you don't need to have such a long 20-year protection term as you have with invention patents, and so it may be it can make sense to opt for utility models. I mean, you have different factors and criteria that can be taken into account. It's a case-by-case analysis that needs to be made with patent attorneys mainly.
Yeah, somebody actually just responded that application time is much longer in comparison to version patent, which is not true. It is actually easier, cheaper.
Yeah,
right?
yeah. It's for the reason I explained. No substantive examination, so it's more a formal examination that is performed, and so it's much more quick.
Yeah, passing on trade secrets. If the audience can vote again, I think last time was not too bad. So there is a misconception that trade secrets are just about contracts, and that is just for business partners. But what's your comment on that? Because it's definitely not.
So yeah, and I think it's what I'm going to say is valid for China, but it's valid for all over the world, especially also Belgium and Europe. This reasonable steps requirement, so this requirement that you have to adopt a set of measures to protect the confidentiality of the information. Well, this you find it in US laws, you find it in the European Directive on Trade Secret, was adopted back a few years back, transposed in Belgian law in 2018. And it's also a requirement that you find in the Chinese definition of what a trade secret is, Article 9 of the Anti-Unfair Competition Law. You have to adopt a set of measures. And in China, what is interesting is that you have the Supreme Court, the highest jurisdiction in the country, that issues judicial interpretations, which are guidance for, among others, judges on how to interpret, understand, and apply the law. And you have a judicial interpretation on this, where they give a whole set of guidance of the types of measures that you should take to protect the confidentiality of your information. I've put a translation in the slide, so you will have them. It's a very useful guidance. And clearly, NDAs are not enough. You have to have strong NDAs that you can enforce in China, and that very often is not the case. So be aware of that, to have good NDAs that can work in China, but it's not enough. You need to take cybersecurity measures, HR measures, organizational measures, strong access management measures, etc., etc. And so indeed, it's not only NDAs, and it's not only business partners. The biggest risks in terms of trade secrets, and that is very much true for China, but again, it's true everywhere in the world, are employees. Employees and ex-employees, that people that are part of the organization, that have access to information, and that at some point decide to leave the organization with trade secrets that they may or may not use for competitive purposes. And so, yeah, it's important to be aware of that. It's important to handle that, including through HR measures. Typically, what is very important to do are entry and exit interviews. When you hire someone and when you have a departing employee, remind him his confidential obligations that can extend after the term of the employment relationship. That is very, very, very important. And again, I'm saying this for China, but it's actually true for Belgium and Europe and the US as well.
Regarding copyright, I think everybody got it quite right, apart from a couple of cases. It can cover software, because I think software protection is one of the trickiest questions that we usually have. But it is possible to cover, to protect software to a certain extent, right?
Yeah, so software is, I mean, the source code is protected. It's a language, and so IP laws have considered that copyright was the best way to protect software and the source codes. So the way it is coded is protected by copyright. It's an automatic protection. So when you code in Belgium, you're protected in China, and vice versa. When you code in China, you're protected in Belgium. But as I explained, you have this voluntary registration mechanism. By the way, there is a guide available on the website of the China IP SME Helpdesk that explains how this works. don't do it by yourself. That's certainly, I mean, contact people that are used to that and that will best help you, because it requires to disclose part of the source code. So you really need to work with good experts to take advantage of the confidentiality measures that you can take when you record your copyright with the Chinese administration. So you need to be careful, but it is recommended, and as I said, very often required to enforce, and sometimes very useful when you license your softwares.
Great, thanks a lot, Valentin, for clarifying those important matters about those three aspects of IP strategy. I think we don't have any further questions. If you do still have some questions, do not hesitate to contact us, and we will respond to you again in confidential way and within 3 working days. Please confirm, Valentin, we can share your slides with the audience after the event. Yeah.
In PDF format.
PDF format. Yes, yes. Well, thanks everyone, and thanks for bearing with us until a little bit too later than predicted, but it was super interesting. Thanks a lot, Valentin. Thanks, Gwen, for organizing this event for us. Well, until next time then.
Thank you very much. Bye-bye. Thank you.
Bye-bye.